How are you? I'm fine, thank you. Sorry to keep you waiting, having a disorganized morning. Um, you were here not so long ago, late last year,
I was here this time
applying
last
for
year.
a position in Limpopo then.
Yes, I was here last
Okay,
year.
so we should not be all that long with you today. We do have the background intel on you already. Um, your application form does not state your place of birth and date of birth and refers to some annexure in your bundle. Why must we troll through this thick sheaf of papers to find out information? When were you born and where were you born?
I was born in Limpopo.
When?
When?
Yes, you are supposed to give us your date of birth. The questionnaire requires it.
Yeah, there was an extra A that I completed.
I can't find the annexure A. You're supposed to state it where the form asks, and you have not done that. That's why I was asking, why must you troll through these documents to find something you could easily state where the form requires you to state it?
Yeah, but the bundle that I have, I've got it, but I can tell where I'm born. I was born
All right.
in Limpopo.
But what is your date of birth?
61 January, 1961 January.
Sorry?
1961 January, January the 1st.
1 January 1961.
Yes.
Okay, thank you. You hold 4 law degrees, a BProc, LLB, and 2 master's degrees
Yes, yes, Chief Justice, yes.
from Limpopo, University of Pretoria, and UNISA, respectively.
That's correct, Chief Justice.
You came through the ranks of civil service. You taught for a brief spell
Yeah,
at the beginning of your career and then joined the Department of Justice
yes.
as an administrative clerk
Yeah,
in both civil and criminal courts.
that's where I started, Chief Justice, yes.
That was 4 years.
4 years, yes.
And then you did articles and went to work for the Lawyers for Human Rights
Yes,
as a
I
legal officer
Yes.
for
Justice.
another 2 years.
Yes, 1991 to 93, yes. 2 years, yes.
And then in 1994, you started your own practice as an attorney
1994, yes.
in partnership with someone else.
Yes.
And in 2008 until now, you've been a member of the Pretoria Society of Advocates and the Limpopo Society of Advocates.
Yeah, Pretoria, up to last year, October. That's when I resigned from that membership.
Just pull your mic closer to you, please, so that we can hear you
Yes,
clearly.
I've been with Pretoria Society from 2008 to last year, October, when I resigned from the thing.
All right. And during this period as an advocate, you've also been a part-time commissioner
Yes,
with the CCMA.
I've been a CCMA, yes.
Okay. You've acted for a really long time. There's mention of 112 weeks somewhere in your papers.
Yes.
Has it been that long?
Yes, 112 weeks, 80 something in Limpopo and 23 in Gauteng.
I'm sorry, I'm still struggling to hear you.
Yes, I've acted in Limpopo and Gauteng, 23 weeks in Gauteng, and then the rest in Limpopo, so 112, all of them.
All right.
Yeah.
And you've, as you told us last time, you've sat in all the courts in the High Court.
Yes,
and you've written judgments on the widest range of legal subjects.
Yes, Chief Justice. Yes.
On your last visit here, you had not, you didn't have a reported judgment. Has that situation changed since?
No, I don't have a reported judgment, no.
Have you written any more judgments?
Yes, since I came, yes, I've written more judgments, yes.
How many?
I think there must have been, it's more than 5, I think, since I came here. Yeah.
When was your last acting appointment?
The last session, I think the end of September.
This past September?
This past September, yes, I was in Gauteng.
Okay. I should probably leave this to the objections committee. Okay, I'll stop here for now and hand over to AJP Ledwaba. Are you related by any chance?
Yes, we share the same name, but we started knowing each other in Pretoria when we are attorneys together.
You are not related.
No, we're not related, but
Okay, thank you. AJP?
Lugupina.
Yes.
I'm greeting him in Ndebele from Limpopo, even though he's not written, but he's still there, and we are proud of the language. Advocate Ledwaba, can you? I see here you acted in Pretoria. You say 23, but according to the spreadsheet I've got, it reflects 27. Are there instances where you acted on pro bono basis in Gauteng?
I can't recall in Gauteng. I recall in Limpopo, but I can't recall if I did pro bono in Gauteng.
But when you are in Gauteng, you've been exposed. You were also in the urgent court. And,
Yes.
Have you done matters or also in the opposed motion court?
I did both opposed and unopposed motions.
In Limpopo, did you deal with criminal trials?
I did criminal trials in Limpopo, yes.
Okay. I see from the GCB, you've been complimented for being punctual and that you conduct the proceedings fairly effectively and efficiently.
Yes, I've seen that. I've seen that, AJ.
And what contribution do you think you can make in the judiciary if you are appointed?
Well, I'll come with a whole of experience, starting from when I was still the clerk and an attorney and advocate. I think I've accumulated enough experience to contribute to the judiciary.
You indicated that you acted for about 112 weeks in Limpopo and about 23 weeks in Gauteng.
Yes, yes.
What-
All 112, 23 in Gauteng and the rest in Limpopo.
And comparing the two divisions, if you are given a choice, why do you choose to be in Gauteng now? To apply for a position in Gauteng?
Gauteng is more competitive compared to Limpopo. We do more than that when we do in Limpopo.
Right. There was a complaint by Amalgamated Lawyers Association, and you've given a comprehensive response to that. Briefly, can you tell the commissioners what is your view or your further contribution in respect of that complaint?
Well, that complaint was a complaint born out of what happened in court on that day when Mr. Maluleka wanted to appear before me while he knew that he was struck from the roll. So our difference started there. I called him and the fellow advocate to the chambers, thinking that we could resolve it. But in chambers, then it went worse. So, and from there, then he told me that he was going to object to my appointment. So I'm not surprised what he's doing to me now.
Are you done?
Yeah. Yes, I'm done. But I've written everything what happened there, and I responded to what he's saying, that I'm not fit and proper. I don't think he's given any reason, because he talks about some people having observed me in court, and he doesn't say who's that person. But the only evidence that I'm asking the commissioner to judge on is what happened on that day, and also what the bodies are saying. So I think I don't agree with what he's saying to me, that it's saying about me.
Okay. Having experienced the workload and the pressures in the Gauteng division, health-wise, are you saying that you'd be able to cope with the pressures in the division?
Yes, I think I will do that. I've been in Gauteng, I think from 1991, that's when I started there. So I even practiced in Gauteng, so I know the pressure. I know what it takes to be in Gauteng, so I think I'll manage.
Premier.
Thanks, CJ. I don't have a question for this candidate, CJ. Thank you.
Thank you. Prof, followed by Commissioner Nkaito.
Thank you very much, CJ. Good morning, Advocate Ledwaba.
Good morning, Professor.
There is a case that I want us to deal with, where you deal correctly with the principle. But nonetheless, I just want to pick your brain on how that principle should be understood. I think it is on page 76, hand paginated 76 of your bundle.
76.
Yes, it is the Nyakani case that dealt with forfeiture of patrimonial benefits.
This one. This one.
I wouldn't know which one it is. Let me just check.
Okay.
Yes,
Yes.
paragraph 23 of that particular judgment, where you correctly state that fairness is not part of the inquiry when one is dealing with forfeiture of patrimonial benefits in terms of Section 9 of the Divorce Act. Yes. There is a case that was delivered by the Deputy Judge President of Gauteng, Sutherland, in 2014, where he questioned this notion that fairness is not part of the inquiry in Section 9. In fact, when one reads his judgment, paragraph 25, he appears to be saying that the role of the absence of fairness is overstated in the inquiry. The question I want to pose to you, based on what you wrote there, and I believe that you are right, do you think that having regard to the lack of development in the jurisprudence relating to forfeiture of patrimonial benefits, and particularly having regard to the fact that there are no statutory and judicial guidelines on how to determine the concept of undue benefit and the concept of substantial misconduct itself, is there substance in the thinking that for some reason fairness can actually play a role in this when applying this remedy?
Well, the case that I quoted here expressly says that fairness is not the criteria to determine forfeiture, because we define what is substantial misconduct as defined in the Act. So there's no way where the Act itself talks about fairness. I think to say that fairness plays a part will be something's contrary to the Act itself. There's no way the Act talks about fairness.
Yes, I accept that point. And I think Sunderland also accepts that point.
Yes.
And I'm not saying he's right and you are wrong.
Yes.
In fact, I'm with you that you are right. But I want to understand, because there is some value in what he's saying. So the question that I'm asking you is, because for you to get to those three requirements,
Yes.
factors for you to be able to make a forfeiture order,
Yes.
ultimately you want to demonstrate that there is undue benefit to the spouse that you want to grant the remedy against.
Yes.
So what I'm saying is, in that assessment, given the fact that there is no judicial and statutory guidance as to what amounts to unduly benefited, and the concept of substantial misconduct itself, is there no merit in the assertion that to some extent fairness can actually play a role in the assessment? That's where the question lies.
Well, I don't think fairness will be used for the purpose of the forfeiture of the benefits. The fairness can be looked at from when you're talking about the conduct of the parties. But to say that he has been unfair to another party to an extent of saying that for that factor, a party must lose the benefit of the marriage and community property. I think I will say that maybe we should look at each case according to the facts. There can be a situation where maybe fairness can play a part. I think I haven't done that judgment of Fatherland, but I think each case may be looked at its merits.
No, but your answer was correct. There's no fairness in the process. We can leave it there. So I wanted to test your brain in relation to that. Thank you very much, CJ.
Thank you.
Commissioner Ngwaito?
Thank you, Chief Justice. Advocate Ledwaba, there are two issues I want to deal with. Number one, the AFT says that the fee dispute where you were accused of overcharging has been resolved and you've received a letter of good standing. Is that correct?
Sorry, I didn't follow.
The Advocates for Transformation, in their appraisal of your application,
Yes.
have told us that the fee dispute
Yes.
that was raised with this commission before has been resolved. You've received a letter of good standing. Is that correct?
That's correct.
How was it resolved?
Well, first of all, what we were differing about the figure, we reached a figure. We agreed on a figure. After the investigating committee...
Sorry, just give me some facts. The charge was that you had overcharged. So how did you resolve that problem?
All right, maybe let me give you the background. The background was this. After I'd submitted the statement, and we agreed on two figures to say this and this should not be there, and then we deducted them. Let me just give the background. And then once we done that, they said...
So what does that mean? I don't understand. You submit an invoice. There is a complaint that you have excessively charged. Do you then remove items from the invoice?
Yeah. What had happened is there was a day when they said to me there was a COVID day, and we're not supposed to appear.
Yes, I understand, but I just want to understand the principle. You removed items from your invoice, yes or no?
Yes, we removed items from the invoice.
You removed items from your invoice?
Yes.
How did those items get there in the first place?
How did they?
Get into the invoice in the first place?
Well, there was a dispute whether that day we set or not set on that day. Because on that day, there was a COVID day. There was during COVID. And the manager said, on that date we said, but the register said we did not, the register said we said on that date, but the manager said we did not sit. Now, when there was a dispute, I said, okay, if that is dispute, let's remove this item. Because on my notes, shows that we attended on that day. But there was a difference between the registrar then and the manager. The manager said, his note says we did not sit. But the registrar said we sat. But I said, in order to avoid that situation, let's remove that dispute. Let's remove that figure. Then we remove that figure. Another figure, when I was calculating, as I entered the figures, as I entered the notes, there was a line where there were two figures in the same line. And when we discussed this thing, I discovered that I'm the one who, because of the movement of figures, two figures remain on the same line. So I said this one should be out because that was my mistake. Those were two figures that were there. So those two figures were removed. Yes. But what happened after those figures were removed, they said to me, then give us a new invoice. And I gave them a new invoice. When I gave them the new invoice, the figure that we had then exceeded the figures on the invoice. And then we sat again to say, let's rectify that. And then the manager and myself, we sat again. His figure again became more than the figures that we said. And then instead of resolving that, the register reported to the committee. And then the committee, investigating committee, said to us, we differ on the figures. Can you resolve these figures? And we said, yes, we can resolve them. And when we went back, then they went back to the original statement where we only agreed to remove those figures that we differ. And then, so the only difference was that because they said I must generate another invoice, I found that the invoice now became more. And with the manager as well, even the figures became even more. So we went back to the original figures, to the original statement, and we just took those two figures. And then we agreed.
Now, just to sum up,
Yeah.
the way this was solved is that there were items on your invoice that you removed. One of the items you admit was incorrectly there. The other item you disputed it was incorrectly there.
So two figures that were
Yes.
there. The figures that I made my mistake, and the figure that register and the manager differed as to whether we said on that day.
Yes.
But I said, in order for us to move this matter, let's remove both these figures, and then remove those figures.
Yes. Now, there is a second issue, not raised by the Advocates for Transformation, but raised by Amalgamated Lawyers Association.
Yes.
The allegation is that you misled although you were presiding in the court, you misled the lawyers by falsely claiming that Judge Patudi said he was conflicted in the Esther Maluleke case
Yes.
on the 26th of March 2024.
Yes.
Judge Patudi sat in the matter on the 16th and specifically said that it was a lie that he was conflicted. In fact, you never even spoke to him on that day.
Yes.
Now, I have a problem that
All right.
a senior judge like Patudi J can say that you've lied about what he said.
All right. There's always two distinctions, two dates. There's a date. The first date is the 19th of March, when he gave me that file. He said to me, I'm giving this file because himself and Chidata are conflicted. We said there.
Yes, but just told there. So he told you that him and Judge Chidata were conflicted.
He told me himself and Chidata were conflicted. And that's the reason, because we were three. The only reason that he gave me this file because he said to me, himself and Chidata were conflicted.
Yes, but the quotation here from Judge Patudi, AML Patudi,
Yes.
he says that, this is what he says. He says, further, it is necessary to correct any misapprehension of the events that may exist.
Yes.
For this reason, I state that it is manifestly and wholly untrue and incorrect that I, by any means, explicitly or implicitly, intimated to Ledwaba AJ that I had any conflict of interest in the above. But
Yes.
you are telling us that this is untrue. He told you he's conflicted. He's saying what you are saying is untrue. He never told you he's conflicted.
Well, he told me that. He told me we were two in these chambers. That's what he told me. And that's the reason that he gave me that file. He said to me, himself and Chitata are conflicted. So I'm the one who must take that file. And that's the reason that I took that file. I know that he denies that he did not tell him, but that's what he told me when he gave me that file.
Thank you, Chief Justice.
Minister.
Thank you very much, CJ. Good morning, Advocate Ledwaba.
Good morning, Minister.
In your questionnaire, you've been asked about what significant contribution to law and pursuit of justice.
Yes.
Amongst others, you reflected on your dissertation,
Yes.
your master's dissertation, where one of the areas you reflected is the tension between labor court and high court, but as well where you made reference to the issues around socioeconomic rights perspective, I must say quite both are impressive in terms of the reference. Maybe if you can explain to us when you cite them as the most significant contribution, is it on the basis of it contributing to the study, being quoted by other scholars, or is it because the two dissertations in terms of how they distribute, they are cited and contribute, it's on the basis of impact in society? I just want to understand, while they are good dissertations that you have been able to make reference to, how do they contribute to society in terms of pursuit of justice?
Well, the one where I deal with the LLM for the UNISA.
Can move the mic closer to you.
To the one that I deal with
Thank
UNISA. I think my contribution is the tension between the jurisdiction of the High Court and the Labor Court, insofar as the employment is concerned. When I researched that, in the cases that I referred there, it showed to me that there's confusion as to whether the applicants are entitled to go to the labor court, or if there's a contract maybe relating to the lease, and there's a relationship between the lessee and the lessor, as to whether this person can go straight to the labor court, he must go to the High Court. But I concluded to say that the labor court came after the Supreme Court. And I said the Supreme Court, the labor court did not take away the jurisdiction of the High Court. The High Court remains with that jurisdiction. So for as long as it's not taken away from that, the person who has got a dispute can also go to the labor court, to the High Court. That's my contribution.
Thank you.
Anyone else? Commissioner Pillay?
Thank you, Chief Justice. Good morning, Mr. Ledwaba.
Good morning, Commissioner.
Mr. Ledwaba, I just want to first ask you, I should say Advocate Ledwaba, I just want to first ask you about your judgments. You've put up before us a sample of the judgments that you've handed down as an acting judge.
Yes.
One of the difficulties that I have, and I want to raise this with you, is that your judgments are written in a very sloppy manner. For example, some paragraphs are numbered, some paragraphs are not numbered. If you go through the judgments, particularly your earlier judgments, you'll find that there are typographical errors, etc. Now, in those instances, firstly, I want to understand how it is that you ultimately hand down a judgment that is riddled with these kind of issues. And secondly, why you would put that up as a sample before us of what you're capable of doing.
Well, I was asked to give the example, the judgment that I regard as best that I could, and I did that. I accept that I may have made a mistake somewhere, but I don't think those are the mistakes that can say to me that the judgment are wrong. But maybe the commissioner can indicate to me where it says this is wrong, this is not right. Because the commissioner just talked about generally.
Yeah, I wanted to raise it generally with you first. I'm happy to get into the detail of each judgment, but we don't have sufficient time. But let's start with your Merifon judgment.
Yes.
You know that judgment ultimately went to the Supreme Court of Appeal and to the Constitutional Court.
Yes, it did.
If one reads both judgments, the Constitutional Court judgment as well as the Supreme Court of Appeal judgment,
yes,
it's almost unrecognizable to your judgment in terms of the court's approach to the issues.
yes.
Now, in that case, a litigant had brought an action for specific performance against the municipality.
Yes.
The municipality had in return brought a counterclaim for the setting aside of the underlying contract.
Yes.
Now, my first difficulty with your judgment is that it approached those two big issues simultaneously. It's all jumbled. Instead of dealing with the challenge to the legality of the contract first. And then if you read the judgments of the Supreme Court of Appeal and then the Constitutional Court, although they agree with your conclusion, what I'm raising with you is how they reason that and how they approach the distinction between the two issues, which in your judgment is conflated.
Well, I don't understand because at the center of that, the whole of judgment was Section 19.
Yes.
They all agree with me. I haven't. I mean, what is written in the Supreme Court and the Constitutional Court, I accept that the standard is different, but they came to the same conclusion that for a purchase like that, you need a municipality resolution. That's what it comes to. So I accept that. I mean, I can't write like the High Court, like this Supreme Court, because there was Spencer who was writing that. I can't compare that standard. And here there was now the Deputy Chief Justice who wrote for the majority. So comparatively, I can't compare, but we come to the same conclusion.
Yeah.
It's about legality.
What I'm raising with you is how you go about conveying your conclusion. And I'm saying that in your judgment, it took a lot of time to sift through your reasoning and to understand your conclusion in light of your reasoning.
Yes, I had to deal with that because that by the time it reached the Supreme Court, many issues have been sifted out. You remember there were also transactions regarding the transfer of the property from one party to another. I had to deal with that at that level. But by the time it went to the Supreme Court, many issues had been shifted. So they did not have to deal with what I dealt with. Mine is very long because it was at a lower and I had to deal with many things. But at that time, when it went to the Supreme Court, the issues were crystallized. So I don't expect that to be the same as where I started because I was still doing the groundwork.
But that's exactly what I'm putting to you. Before you, the issues were crystallized.
Yes.
It was the legality of the contract, and if you found that the contract was not lawfully concluded, then you didn't need to deal with a specific performance issue.
There were many things because remember there was also authority from the Treasury and everything. So I had to deal with that because by the time they went to the Supreme Court, they went for specific issues, not the issues that they raised there. But I had to deal with those issues because they raised those issues. But when they went to the Supreme Court, the issues were crystallized. It was straight to Section 19. It was illegality about that one. But there were not any other issues. But I had to deal with that one. It's different from when they were at the Supreme Court. And at the Constitutional Court, they just went straight to say, we're dealing with legality here.
One of the issues dealt with by the Constitutional Court was the question of delay. Whether or not a municipality has to
I'm
provide...
struggling to hear, Commissioner.
One of the issues, and this goes to what I'm trying to engage you on, which you don't seem to be accepting, Advocate Ledwaba. One of the issues, critical issues, which the Constitutional Court focused on was the question of delay, where a municipality raises as a defense the invalidity or unlawfulness of the contract, whether they have to provide a full explanation for the delay before they raise that defense. Now, one doesn't see that in your judgment at all.
I lost a bit. I think. I just heard you say the delay.
Yes, it's being dealt with, for example, by the Constitutional Court. It's one of the critical decisions that they make. They consider whether or not the municipality was obliged to give a full explanation for the delay in bringing the defense that the underlying contract was unlawful. But you don't consider that at all in your judgment.
I don't know what issue was raised there at the Constitutional Court, but it was about all this issue was about the authority of a municipal manager having transferred the property without authority from the council. But I don't know what questions were asked there that led to to what the commissioner is talking about now.
All right. Just a second question, Advocate Ledwaba. You're aware that on the 9th of August 2025, the judiciary adopted the sexual harassment policy.
Yes.
Have you considered the sexual harassment policy?
Yes, I've read that.
And in your view, what are the kinds of challenges the judiciary will face in implementing that policy?
Well, when I read that policy, it reminded me of the sexual harassment at workplace. And I said, except that it's broader than the sexual harassment at place because it covers a broader space. I don't think there will be many challenges in implementing this, given the experience coming from what happened at the workplace. I don't think there will be many challenges. But yes, it covered a wide spectrum compared to the sexual harassment at workplace.
And why do you think it's necessary to cover a wider spectrum in the judiciary's sexual harassment policy as compared to the code of conduct?
Well, it covers, when I looked at it, it covers a wide range of people. It talks about even from the staffing and everybody else. It covers a wide range. And I think that's the reason why it's broader than what I thought at the workplace.
My question was, why is it necessary to cover a wider range of conduct?
Well, I think it comes out of experience that's happening. I mean, I thought that is something that comes experience to say we need to deal with these issues so that it doesn't get out of control. So it must be dealt with in a way that everybody understands within the judiciary. That's how I understood it.
Thank you, Chief Justice.
Thank you, Commissioner Pillay. Anyone else, colleague? Commissioner Moimang?
Thank you, CJ. Good morning, Advocate Ledwaba.
Good morning, Commissioner.
Just one from myself, in relation to the transformative impact of our constitution on South African law and politics. Can you just reflect on how did you ensure in this judgment of Malikana that the rights of those that are mostly vulnerable in society are protected? Because this is the judgment that you also refer to as your contribution to jurisprudence. Thank you.
Which case, Commissioner?
It's Malikana AM versus the National Director of Public Prosecution. It dealt with the
Marikana.
Yeah, Malikana.
Oh, Malikana. Oh, okay.
Yes.
That is the case that let me put it in this way. There was a situation where an attorney is married to a wife, and the wife is sitting at home. The attorney goes out and do what the Law Society says is a misconduct. And there's a property that was bought before the Law Society found that there was a misconduct. And then at the end of the day, they want to do a forfeiture. They come to a house. They come to the property. And what they found in the property, the only thing that they found is a house. And now this house, the law says, is an undivided half share of a woman. And it's a very old lady who is a pensioner now. Now, that house has been attached. Now, the issue that I'm raising there is we have a situation where very old lady who had nothing to do with what the husband was doing, now the house has been attached. Now, this house is going to affect this woman. And I was also raising the issue that even this old man, now he's so very old, he's at home. Now, that is the only thing that they have. If this house is sold and on the basis that it's a process of a misconduct, how it affects these people, that is an issue. And this matter is still pending in the Mpumalanga High Court. It's a matter that I think I want to see through it, because it's very, very important to say, if at the end of the day you've got old age people who the only thing that they have is the house, and the house gets attached, is it what must happen? And what must happen to these old people who can no longer afford to raise a bond? They're going to be on the street at the end of the day.
Thank you, Advocate. That is the concern that I have, that this is a 2008 case, and you have just also confirmed that the matter is still pending before the Mpumalanga High Court between 2008 and 2025. Are you sure? What's the situation? When is it going to be finalized?
What happened, that matter, I argued that matter in the Gauteng High Court, and two judges were allocated to deal with that matter. The two judges did not agree what must happen, whether the house must be forfeited. And then matter went back to court again. But instead of being allocated again, then there was in Mpumalanga High Court that had started, and the matter was transferred there. The way I understand that the delay now is to get the record from the High Court, from the Gauteng High Court to Mpumalanga, so that this matter must be finalized. So that's how it takes a long time. But it's a matter that I wanted to finalize.
Thank you, Advocate Ledwaba. Thank you, CJ.
See?
Thank you, CJ, and morning, Advocate Ledwaba.
Thank you. Morning, Commissioner. Yes.
Can you see me? Thank you. Just one minor aspect. Page 74. The paginated 74, paragraph 91. I think it's about the same Merifon judgment.
Yes.
Yeah. Paragraph 91, is that part of the order?
Yes. Yes. I think there was an issue that was not dealt with in the previous judgment.
Yes, but are you ordering what? What are you ordering? Just to save time, to me it appears to be a discussion, not an order, and it should not be under the heading orders, because it might confuse the parties as to what should happen. And it suggests that they must accept an
yes, I was saying that it must be dealt with. It shouldn't be. I think I can't record it, but I think this issue was also raised, and I said it should be dealt with in another judgment.
Is that the order, that it must be dealt that way?
No. I was just making a remark. That's not something that he can deal with. Yes.
Orders should not have remarks, because they must be specific as to what should be done. Isn't it?
Yeah, because it was raised, I had to deal with it to say, I can't deal with it. It must go back.
But is it not misplaced under the order? It
Oh,
should have
okay.
been in the body of the judgment.
Oh, yeah, yes.
Order is what you are now determining.
Oh, yeah. No. If you say it should not have been yet. Yes,
Thank you.
Commissioner Nokonyan?
Good morning, Chief Justice. Good morning, Commissioners. Good morning.
Good morning, Commissioner.
Just as a follow-up to the response to Commissioner Ngwaitobi,
Yes.
as regards the dispute of fact that you are raising between you and Judge Patuti,
Yes.
is there any reason why must we believe you and not believe him?
Well, that is a question that I was asked at the other time, to say who's telling the truth. I can only talk about me because the last time I was asked whether I'm telling the truth or I'm telling the truth. It's something that's happened in the chambers. I'm going to leave it to the commissioner to do. But I think what the commissioner must look at is how this matter was dealt with. This matter, at the end of the day, the judge president himself, for a reason that he did not say, he ordered that this matter not be finalized before Patudi. He ordered that the matter must be taken to Polokwane, and he gave it to the High Court. There may be a reason for that, but I'm not saying that it's wrong, whatever, but that, to me, told me that the judge president, maybe there's something that he knows that I don't know. Because otherwise, why would he say Judge Patudi must never dealt with this matter? The matter must be taken back from Toyando to Polokwane. So on that basis, I think maybe the commissioner should just consider that.
The substance of a dispute is about what you told counsel in court proceedings.
Yes.
And the question is, why would he say you actually lied to those legal representatives? Is there any reason why he would do that against you?
Well, I don't know why would he say I lied to them, but I still don't understand why would he give me the file, give me the reasons why he's not going to deal with this file. The next thing he says, no, I never did that. Because what should we look at? And I said, let's look at where was this matter? This matter was before him on urgent basis. Why did he not deal with it? And I accepted that when he told me. So why he would now turn around and say, I never gave him as the reason why he's not dealing with the matter, I don't know. But and there's no reason for me to lie to the parties, to say, I was told by Patu to deal with the matter because he's conflicted with both himself and Chitata. There was no reason for me to lie to the parties. I don't know why would I lie to the parties that I've taken this matter because it was given to me for this basis. I don't know why would I also lie to them, to the parties.
Thank you, CJ.
Thank you, Commissioner Nkwenyen. We have finished your interview, Mr. Ledwaba. You're excused. Thank you.
Excused?
Yes?
Oh, thank you. Thank you. Thank you. You know,